Welcome to Making a Murderer, Rubberducky video channel. Well, we finally got a filing from the Circuit Court Judge, Angela Sukowitz, and it is August 8, 2019. Released by the court, Angela W. Sukowitz, Circuit Court Judge, 8/8/19. State of Wisconsin versus Steve Avery, decision and order, case number 05-CF381. This case was remanded to this court for consideration of claim made by the defendant for the relief from what he asserts was the state's violation of Wisconsin Statutes 968.205 and the subsequent violation of his constitutional rights pursuant to the ruling in Youngblood v. Arizona. Prior motion to the Court of Appeals was denied. The defendant alleges that on January 24, 2019, his current post-conviction counsel received a previously undisclosed police report. The report, dated September 20, 2011, was written by Deputy Jeremy Hawkins of the Calumet County Sheriff's Department. The defendant further alleges that his counsel received a previously undisclosed ledger sheet on or about the same date that identified the material that was the subject of Deputy Hawkins' report. The report of Deputy Hawkins indicates that he, Sergeant Investigator Mark Weger, Attorney Thomas Fallon, and Attorney Norm Gahn removed materials, stored in evidence, and released them to the Halbach family. The officers and attorneys identified which tagged items of evidence were alleged to contain human bone or possible human bone fragments. In order to accomplish this task, the parties used a report of Dr. Leslie Eisenberg, the forensic anthropologist called as a witness by the prosecution in this matter. Jeremy Hawkins used Dr. Eisenberg's report to identify evidence identified as having come from the gravel pit southwest of the Avery property in deciding which materials were to be returned to the Halbach family. The defendant alleges that the state violated the Preservation of Evidence Statute, Wisconsin Statute 968.205, which requires law enforcement agencies to retain evidence as long as a convicted individual is in custody or until his or his mandatory release date. Additionally, the defendant asserts that his constitutional rights were violated when he was deprived of the opportunity to have the alleged human remains tested. If such a test proved that the material marked with the designated evidence tags were human remains and could be identified those of the victim, the defendant asserts that it would establish that the evidence had led to his conviction was planted by the real killer in this crime. On January 24, 2019, the defendant filed a motion with the Court of Appeals requesting that the appeal in this matter be stayed and remanded to the Circuit Court to review the circumstances regarding the withholding of records and the release of the evidentiary materials to the Halbach family. Additionally, documents were filed by both the state and the defense regarding this motion. On February 25, 2019, the Court of Appeals granted the motion to remand these issues to their Circuit Court for consideration and decision on the issues. That decision will then be permitted to be included in the continued primary appeal before the Court of Appeals. The Court of Appeals was clear that the supplemental motion was restricted to reviewing whether the state violated Wisconsin Statutes 968.205 and how such a violation would affect the constitutional rights of the defendant. As such, the court will limit its review to these issues alone. As the defendant stated in his brief, Mr. Avery is not stating a sufficiency of evidence or ineffective assistance of counsel claim relating to inadequate testing of bone fragments. Rather, Mr. Avery's claims pertain to the constitutional violation stemming from the state's destruction of the human bone fragment evidence. The retesting of the bones is relevant to this constitutional claim on the matter of the exculpatory nature of the destroyed evidence. However, The retesting of the bone fragments is not a claim in its own right. However, before the court addresses the primary issue, it feels compelled to address the recusal motion brought by the defendant. It is apparent from the record that there are no grounds upon which to grant that relief. The civil case referred to by the defendant, in which he was named as the party, was judicially reassigned to this court, but the case was immediately stayed pending the resolution of the defendant's criminal appeal. Before any proceedings were conducted by the court, the matter was voluntarily dismissed. The court neither examined any evidence nor issued any ruling in the civil case, other than to grant the motion for voluntary dismissal. The administrative assignment of the defendant's civil case to this court does not form the grounds for a recusal in this action. As further evidence in support of the request of recusal, the defendant argues that this judge served on the Crime Victims' Rights Board along with District Attorney Kratz during the time that the original trial in this matter was being heard. The defendant asserts that by being on the same volunteer committee with the prosecutor at the time of the trial, the judge in this matter must recuse herself. The defendant relies on SCR 60.04 for this proposition. However, that provision of the Judicial Code applies to judges who have practiced laws with attorneys involved in matters before the court. This judge never practiced law or participated as counsel with Attorney Kratz on the defendant's criminal trial or in any other matter. At the time in question, this judge was not serving on the bench and was a citizen member of the Crime Victims' Rights Board. The fact that Attorney Kratz was on the same voluntary public board at the same time as this judge cannot be defined as the practice of law. The defendant has offered no grounds upon which the court should recuse itself. Further, the court must comment on the defendant's objection to the state's response brief. In another motion before the court submitted April 11, 2019, the defendant asked for leave to file a supplemental response brief in this matter in the alternative, to strike the state's response brief as being unauthorized under the remand order of the Court of Appeals. The Court of Appeals states in its order that this court shall conduct any proceedings necessary to address claims in the supplemental motion submitted by the defendant. The order acknowledges the defendant's position on this matter and determines that the best course of action is to have this issue developed and litigated while the matter is still relatively fresh and not procedurally barred. The defendant echoes this argument in his filings, asserting that his motion should not be procedurally barred and that all claims raised by this motion should be heard by the circuit court. Both parties have filed briefs in this matter, and all arguments will be considered. Regarding the issue at hand, this court has been charged with determining whether Wisconsin statutes 968.205 has been violated by the state during the post-conviction period, and whether any such violation of the statute deprived the defendant of the rights provided to him via the ruling in Youngblood v. Arizona Supra. Both parties submit numerous arguments and allegations in their briefs. However, the court will address only those arguments that focus on the charge given to it by the Court of Appeals. Wisconsin Statute 968.205, Section 2 states, except as provided in subsection 3, if physical evidence that is in the possession of law enforcement agency includes any biological material that was collected in connection with a criminal investigation that resulted in a criminal conviction, and the biological material is from a victim of the offense that was the subject of criminal investigation, or may be reasonably used to incriminate or exculpate any person for the offense, the law enforcement agency shall preserve the physical evidence until every person in custody as a result of the conviction has reached his or her discharge date. Emphasis added. The first clause of the statute does not apply to this matter. None of the material returned to the Halbach family was scientifically identified as the physical remains of Teresa Halbach. No DNA testing was performed on material returned to the family that conclusively identified the material as belonging to a human being or any specific individual. Indeed, at the time of the trial, the FBI crime lab indicated that DNA testing could not be done on the evidence submitted, precluding identification of the remains as being those of the victim. Without any such identification, the evidence in question cannot, within the plain language of the statute, be identified as biological material from the victim of the offense at issue in this case. However, this does not end the inquiry into this matter. The second clause of the statute may apply in the case before the court. The defense argues that the evidentiary material returned to the Halbach family might reasonably have been used to exculpate Mr. Avery and establish that biological evidence was planted on his property to incriminate the defendant in this matter. The defense argues that the evidence recovered from the quarry site may have proved that the victim was not killed on the Avery property, as argued by the prosecutor, and that the evidence found on the grounds of Avery Salvage Yard were planted there by the real offender in this matter to incriminate Mr. Avery. Because the evidence is no longer available to the defense for testing, the defense argues that it can no longer use the material to exculpate Mr. Avery of this offense. Furthermore, the defense argues that the state further violated the statute by not providing the required notice to the defendant or his counsel prior to disposing of the evidence, preventing the defendant from exercising his opportunity to object to its release or destruction. Wisconsin Statute 968.205 subsection 3 provides that the law enforcement agency may destroy evidence covered by this statute before the time specified in subsection 2 only if all of the following applies. A. The law enforcement agency sends a notice of its intent to destroy the evidence to all persons who remain in custody as a result of criminal conviction, and to either the attorney of record or each person in custody or the state public defender. Subsection 4 of the statute provides what shall be included in such notice. A notice provided under subsection 3A shall clearly inform the recipient that the evidence will be destroyed unless, within 90 days after the date of which the person receives the notice, either a motion for testing of the evidence is filed under 974.02 subsection 2 or a written request for the retention of the evidence is submitted to the law enforcement agency. There is no dispute that the evidence in question was released to the Halbach family without the statutorily required notice under subsections 2 and 4 being provided to the defendant or the defense attorney of the record in this case. However, the inquiry into the matter is not terminated with this issue. In order for the statute to apply, the evidence in question must reasonably be used to incriminate or exculpate a defendant for the offense. The ruling in State v. Greenwald incorporated both of the tests cited by the defendant outlining the constitutional requirements of the state's responsibility to preserve evidence as set forth in California v. Trombetti and Youngblood v. Arizona. The state's failure to preserve evidence violates a defendant's due process rights if law enforcement 1. failed to preserve evidence that is apparently exculpatory, or 2. acted in bad faith by failing to preserve evidence that is potentially exculpatory. Greenwald Supra at 67. The defense is correct in asserting that Wisconsin courts have applied the reasoning in these cases to the post-conviction destruction of evidence, State v. Parker, 2002. In order to establish that the evidence in question was apparently exculpatory, a defendant must demonstrate that the evidence possessed exculpatory value that was apparent to those who had custody of the evidence before it was destroyed, State v. Onus. It is not enough to simply allege that destroyed evidence had the possibility of being exculpatory. ID, evidence does not have apparent exculpatory value if analysis of the evidence would have provided an avenue of investigation that might have led in any number of directions. Youngblood, Supra at 57. The defendant argues that the evidence returned to the Halbach family contained human remains that, if tested under currently available DNA testing, specifically Andy rapid DNA analysis, could be conclusive in identifying the remains as belonging to the victim, Teresa Halbach. However, it must be noted that the defendant begins his argument with the conclusion that the evidence turned over to the Halbach family were, in fact, human remains. The defendant points to several portions of the record where the evidence that was collected from the quarry site was listed in police documents or reports as human remains. The defendant specifically cites a police report of Deputy Hawkins dated September 20, 2011, in support of his claim. Defendant's Exhibit 13. In that document, Deputy Hawkins writes that he, Sergeant Investigator Mark Weger, Attorney Thomas Fellon, and Attorney Gahn removed evidence with property tag numbers that were listed as having contained human bones. They determined which of the evidence samples contained human bones by using a report authorized by Dr. Leslie Eisenberg. Dr. Eisenberg was a forensics anthropologist called as an expert witness by the prosecution to identify the evidence collected from various locations during the investigation of this case. The record in this case contains more than one document created by Dr. Eisenberg, and the report written by Deputy Hawkins doesn't identify the specific document used by the parties on that date. In her final report submitted to District Attorney Kratz on December 6, 2006, Dr. Eisenberg set forth her conclusions identifying which evidence applied for analysis contained human bone fragments and what was identified as material other than human in origin. On February 28, 2007 and March 1, 2007, Dr. Eisenberg testified at the defendant's trial. She was questioned extensively by both Prosecutor Fallon and Attorney Strain regarding her conclusions in that final report. On March 1, 2007, Attorney Strain cross-examined Dr. Eisenberg. Attorney Strain questioned the doctor about material discovered in the investigation area referred... we have a big blank page on page 10. Referred to as the quarry in investigative reports. During his cross-examination, Attorney Strain asked the doctor about two fragments of material that appeared to be pelvic bone. However, Dr. Eisenberg testified she was not able to conclude with scientific certainty that the fragments were pelvic bone or that they were human in origin. After questioning the doctor about other aspects of the opinions in her report, Attorney Strain returned to the evidentiary material found in the quarry. Dr. Eisenberg tested that, at the time of writing her report in December 2006, she could identify 8 of the fragments were burned, and one of the fragments was definitely not human. She qualified that her opinion on the material was, at that point of her analysis, as much as she knew about the identification at that point in time. In continued cross-examination, Dr. Eisenberg once again confirmed that the quarry area contained suspected possible human bones. Attorney Fallon conducted a redirect examination. Attorney Fallon asked Dr. Eisenberg to clarify her opinion on the nature of the fragments found in the gravel pit at the quarry southwest of the Avery property. Attorney Fallon asked if, in her original analysis, the doctor was able to determine that one fragment of the material recovered from the quarry was non-human. Dr. Eisenberg confirmed that. He then asked if, in subsequent review and analysis, the doctor had determined that several more of the fragments were non-human. Dr. Eisenberg responded that all of the fragments, only 3, were identifiable as being possibly human in origin. Responding to a question from Attorney Fallon, the doctor confirmed that she could not, to a reasonable degree of anthropological or scientific certainty, identify any of the fragments as human bone. On cross-examination, Dr. Eisenberg stated that the material from the quarry location did, in fact, contain non-human bone that was intact. The doctor confirmed that the burned bone fragments could be found at all 3 sites where evidentiary material was found. However, she could not confirm with any degree of scientific certainty that any of the bones from the quarry were human in origin. As previously stated, pursuant to the ruling in Greenwood Supra, for evidence to be apparently exculpatory to law enforcement, the defendant must demonstrate that the evidence possessed exculpatory value apparent to those who had custody of the evidence before it was destroyed. In this case, the defendant cannot meet his burden. While the defendant points to the report of Deputy Hawkins, which indicates that human bones taken from the quarry were returned to the Halbach family, the statement of the deputy does not transform the physical material from what it is into what he declares it to be on the form. Dr. Eisenberg testified at trial that the evidence taken from the quarry could not be identified as human remains. The FBI could not test the bones to determine if the fragments were human or, if so, to whom the bones belonged. Nothing of record indicates that in 2011, when the material was given to the Halbach family, the material was reclassified as human bone. The law enforcement officers and attorneys involved in the release of the evidence used a prior written form of Dr. Eisenberg, written before her testimony under oath, to select what material would be given to the Halbach family. Dr. Eisenberg clarified her opinion in her trial testimony and confirmed that none of the material found in the quarry could be identified as human bone fragments. Furthermore, the FBI confirmed that the fragments could not be tested for DNA to confirm whether the fragments were human or identified as those of a victim. Under those circumstances, it cannot be said that the materials released from the evidence would have been apparently exculpatory to anyone. There was no scientific evidence or record at the time that this material was released to support that the human biological material was being released or that material was known to be the remains of the victim. The defense argues that it would be absurd for the state to release the bone fragments to the Halbach family if it didn't believe the material released was the remains of the victim. Therefore, the defendant argues, the state acknowledged that the material released was apparently exculpatory. However, if law enforcement believed that the material was human bone, their belief would not be founded in science or in any final evidence produced during the investigation or trial. They would be acting on unfounded belief rather than the reasonable belief as required by the Greenwald test. Individual belief does not transmute one form of matter into another. Nothing supports the position that the materials released were apparently exculpatory. Even if the defendant cannot meet the burden that the material released was apparently exculpatory, the defendant may meet the constitutional test for a violation of his rights under Greenwald if he can establish that the state acted in bad faith by failing to preserve evidence that is potentially exculpatory. To establish bad faith, the defendant must show that law enforcement was aware of potentially exculpatory value of the evidence that they failed to preserve and acted with either official animus or a conscious attempt to suppress evidence. In this matter, the defendant cannot show that the state knew of the potential exculpatory value of the evidence. As stated above, Dr. Eisenberg testified that the remains could not be identified as a human being of origin, and the FBI confirmed that the evidence could not be tested to confirm whether the material was from a human being or that they were the remains of the victim. Dr. Eisenberg also testified that the material found in the quarry, tagged as number 8675, was largely unburned. This does not support the defendant's argument that the victim was murdered and burned in a place other than the Avery property and placed there at a later date. Given the testimony of Dr. Eisenberg and the lack of any evidence supporting the release material being human in origin, it cannot be said that law enforcement was aware of any potential exculpatory value of the material that they did not preserve, and that they were making a conscious attempt to suppress evidence favorable to the defendant. Based on the foregoing, the court finds that the defendant has failed to meet his burden to establish that Wisconsin statutes 968.205 was violated, or his constitutional rights were violated under the provisions of Youngblood v. Arizona Supra. After such, the defendant's motion is denied. All right, you guys, I am not a lawyer. I'm not pretending to be a lawyer, but this is pretty easy to figure out for me. First of all, we want to go on. We want to get to the appellate court. We want done with this judge. There is no recusal that they are recommending. It's a complete denial of everything. The problem is, with this entire thing, we have, after the trial of Steven Avery in 2007, there was a hearing. Every bit of this evidence was requested to the court to maintain it for future use for DNA identification, and identified that it may in the future be considered exculpatory. So they discussed it prior and said, okay, the court 100% agreed to protect this evidence in case that did occur. Norm Gahn was part of that specific agreement. He is also part of this specific event when these bones are being handed off to the Halbach family. So, in light of that, we have a big problem with their, oh, you can't prove it's exculpatory. You'd have to prove that they knew that it was something they were supposed to keep, but they didn't. Bull crap. You had a court hearing. You agreed to hold on to the evidence. It isn't even just the state law that we're talking about. This is a court hearing. This is a council sitting around a round table, all agreeing that the evidence itself, all biological evidence in the case, was going to be maintained. At what point did you forget that you were in that meeting, that you agreed to that? You may have a bad memory, but we don't. And the fact is, that in itself, we will find out that Zellner comes back and says, hey, you knew, you agreed to it in a court of law to hold on to it. So the fact that you broke that law, yeah, you destroyed the evidence. And why on earth, let me ask you, why would they give back the Halbachs random bones saying that they're not human? Why would the Halbachs want some dead animal bones that are laying down in the quarry? Why would they bury those bones? Please, this is silly. You need to do your job proper when you're in the courts. Realize you're dealing with human lives and that the world's watching, and we're not buying your silly crap anymore. Zellner has us nailed 3 ways to Sunday because of the court that they set up the protection on the biological evidence. And then to back it up further, it's the state law. So, you did not, and you fully admit, you did not contact the incarcerated victim, or I should say incarcerated individual. In this case, it's a victim because they're innocent and wrongfully convicted. You didn't contact their public defender, their lawyer, their attorney, whatever you want to call it. You just did it, and you didn't tell anybody, and you did it sneaky, and we know that. So that's what this is about. Now, where do we go from here? That's a great question. I would watch Tracy, pay attention to what she's telling us. I'm sure she'll go over this, and we'll try to understand it better from her point of view. However, that is absolutely the fact. There was a court hearing. This evidence was supposed to be maintained. So now claiming that you didn't know and nobody knew to maintain it because blah, 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 doesn't matter what you said. You agreed to it. That's the rule. You by law agreed in a court of law to maintain it. You've broke the law. It's that simple. That simple. So we can sit here and we can read on. About the recusal, I get it. You say, no, she wasn't acting in a judge on the bench kind of thing when she was working with Kratz, so Judge Suckowitz wasn't really working on the bench. What about the fact that the Hallbachs actually had sued Stephen and Brendan in a civil suit? And it was to take away any form of money that they would use to defend themselves, to take away any lawyer. And when the Hallbachs did this, the judge recused himself and a new judge was appointed. And she was acting in a case against Avery with the Hallbachs suing him. So yeah, she did get involved in this case. She was involved in the civil suit. So it doesn't matter if she's sitting on some board across the table from Kratz as much as it does that she absolutely was involved in that case at that time when she was sitting on that board. She could be sitting on that board across from Kratz, no problem, as long as she's not involved in her active judge title role with Steven Avery in any way. But we do have her. She's the one that allowed the Hallbachs to drop the case, and her gavel closed that court case. So that is an outright lie that they are telling us in this. Let's go on to look. Is there anything else we want to kind of knock around? I feel that this is what we expected to see. We all knew we were going to get a denial. I feel that they really have backed themselves into a tight, neat little corner here, and they just are not getting it. But they're going to get it when we get our day in court. They're going to start understanding it and comprehending what's being said. You don't break the law and get away with it when the people themselves are the ones that put you in office, and we find out that that's how you do business. So there you go. I hope this helps a little, but I would go watch Tracy, get the down low on the legal aspect of this and what's next. And I thank you so much for joining me as Rubberducky on this. We'll talk to you later, and have a great night. Oh, wait, don't go away. Oh, I almost forgot. We have huge podcasts coming up that we promised. You thought I forgot because I did. Ooh, I've been so busy all day. I've just been like, woo, 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 woo. Anyway, one of the podcasts is going to be out tonight, and it is going to be about the brand new evidence that no one has seen except the people on this podcast in the Darlie Routier case that proves she could not have done it herself. So we have another wrongful conviction here, and you'll have to bear with me, but we'll try our best to show it all in a fashion that you can understand it. It's a very informal podcast where we bring in a group of people, we show the evidence, and we let them push around the evidence a little bit, and we welcome you to join us with that. There will be 2 or 3 podcasts that back it up, and so you'll need to watch them all kind of back to back, I think, to understand the full weight of it. Plus, I'm sure we'll be doing a video to really walk through the details and so forth. But we wanted to get the evidence out there because as soon as possible, because Darlie Routier is on death row facing lethal injection, and we don't have time to goof off. We don't have time to sit here and think about things and talk about the color of anything. So with that, we have contacted the Innocence Project, and we would like to share with you what they were given, and we're very excited to bring that information to you. Please bear in mind that I'm running a little bit later than normal, so the second podcast won't be out until much later this evening, but as soon as it's available, if you've checked that little bell and you've let YouTube know that you will accept notifications from the Ducky channel, you should get a ding, but it will be out by 9 o'clock tonight for sure, if not a little sooner. All right. Thank you guys very much for joining me on that, and I hope you join us this evening for our podcast with the brand new evidence on the Darlie Routier case. And you know what? If you didn't do the crime, you shouldn't do the time. Thank you and have a wonderful evening. Hope to see you later.